Anyways, I'm just gonna start right off the bat. This whole lecture is about the legal essentials of starting a game studio, since I've heard that's what a lot of you are about to do. But before we go deeper into that topic, why should you even listen to this long-haired lawyer dude? Well, about me a little bit. Miikka Kaartosalmi is my name. I am, by background and profession, a technology lawyer. I've been doing a lot of work with a lot of different technology companies. A lot of those have been game companies. Don't have too many public references I can drop here. A lot of it's confidential stuff, but Nola Games, they did Noita. I did some work with them. Metacore, I did some stuff with them. And then one that I don't think is... Anyways, I'm not going to go with that. Anyways, I've been doing a lot of stuff with different technology companies, game companies, stuff like that. And now I've started pivoting more from the general technology side of things into the law of games and gamers and stuff like that. I've done cases, everything from doing HR policies for game companies to helping the guy recover his RuneScape account. That was an actual case, really interesting. Did not get his account back, sadly. But I am also a game designer and a game design student here at XAMK Kouvola, where I'm currently sitting at the art house with my beautiful backdrop. I'm also an entrepreneur, so I've got a company called Games Done Right Oy, so a limited liability company, and I do game company, like law for game companies, and I also develop my own games under the company, and I do some game design consultancy here and there. Yeah, I'm also developing a game. So as are many of you, I'm doing a pinball roguelike. Still very early stages. Got a playable prototype in Unreal, but that's basically that. So a long way ahead. I think many of you are much ahead of me. So applause for you guys that have done a lot of good work already. Yeah, a few questions to you before we go. I'd like to get a little baseline of where you guys are at. First of all, just you can type in the chat. Just say me, whatever, if you have ever in your life signed a contract. Any kind of contract. People are typing. There are yeps, probably me's. I assume there's a lot of yeses here. All right, then. How many of you have actually, from start to finish, read a singular contract? Ever? Any type of contract goes. Oh, yes, maybe. Yes. A lot of yeses still. Good. Very good stuff. Job contract especially. Yep. It's pretty good that you read those before you sign them. And then lastly, how many of you have ever made a contract by yourself, like created from pretty much from start to finish? Someone is typing. Oh, that was a no. Okay. All right, few yeses. Quite a childish. A childish contract is better than no contract, usually. So I still bill of sale on a typewriter when I was 9. That counts. All right. So this topic, this lecture, will be. I can't remember the guy who came up with the 80-20 principle. I'm trying to give you the 20% of the legal essentials that will bring you 80% of the way there. I'm not going to go into deep detail. I've got a lot of little topics that I will go through. I'm not going to do a deep dive. I'm going to give you the bare essentials, the biggest tips and tricks, where you can find more information, where you can find certain documents, certain contracts and stuff of that sort. So instead of diving really deep into very boring legal stuff, I'm going to try to keep it very surface level. And this next, about, let's say 45 minutes-ish from yesterday was 50. But we'll consider about the following, a little bit of extra. Founding a limited liability company, that's LTD, so Oy in Finnish. So what's like the general, what actually is a limited liability company? What kind of paperwork is required for you to start one? And then we go into shareholders agreement, which is if you start a company together with the few founders, that is by far your most important agreement. Then contracts with project contributors, some IPR, so intellectual property rights, so stuff like copyrights and licenses, stuff like that. Then we go a tiny little bit into data protection, and then everybody's favorite that no one has ever read, except me, sadly, terms of service and end user license agreements, which is what you're definitely familiar with, at least to an extent where you've seen them and accepted them a few times. But before we move into that meat of everything, I'm gonna straight off the bat give you the two absolutely most important and essential lessons of this whole presentation. You can sleep the rest of the presentation if you just listen to this one. The rest are way less important than these two. About the sleeping part, by the way, when I did the test run yesterday with 4 friends, they had Subway Surfers in the background, and only one of them sleep. So do that after these two. But that's okay. This is good sleeping ASMR. Legal talk usually is. But the first of your very, very, very important lessons is that the absolute most dangerous sentence you can hear or say when it comes to any legal stuff, any of the bureaucracy. Oh, you don't have screen share on, by the way. I am very sorry. I will fix the situation. Luckily, you only saw my most boring slides. I think this is the right one. Can you see my screen now? Wonderful, beautiful. You didn't miss much. Okay, so by far the most dangerous sentence that you can hear or say when it comes to any legal stuff of your company is, come on, trust me, bro. This sentence is the one that I've seen destroy friendships. I've seen this make products that are almost ready, not being launched at all. I've seen this bankrupt companies, several ones, and it just does all sorts of nasties. And what do I mean with trust me, bro? Stuff like, we don't need an agreement. We're good friends. Like I think a lot of you are, or classmates, and we know each other. We don't need an agreement. Or we're just gonna do the paperwork when we get a bit more serious, because it's just kind of playing around right now. You know, we don't need anything too concrete. We trust each other. Or talking about numbers is awkward. We are all on the same page, right? Well, I just went through this hurdle with a co-contributor of mine. We were not on the same page. We had the awkward talk. It was very awkward, but it was very, very helpful and healthy. And then, personal favorite, not really game related, but a pre-up why we love each other and we're gonna stay together forever. Always works, right? So always, or rather, never trust me, bro. And always talk things through with the people that you're working on stuff with. So instead of just assuming that everybody is on the same page, because in your brain you might think that this is the only sensible way of thinking about this thing. In reality, it most likely is not. And if you do not talk about these things and they arise after the project is, let's say, nearly finished, that can really create some traffic jams. It can really hurt things. And then after you've talked things through, make whatever you agreed and talked about black and white. So have some sort of an agreement. It doesn't have to be a written contract. It's okay Preferably a written contract, but if you cannot do that, if that's too much of a task, then what you can do is just Discord, WhatsApp, whatever you use, and just write those things in your both are or you all are in, and that's kind of an agreement already. So at least you have something in black and white. At least do that. And then for your next big, most important rule, which is a very hot take. You guys are going to hate me for this one in the beginning, at least. Use AI. I am, when it comes to legal stuff, I'm a very, very pro AI. I think it's a lovely, lovely, good tool. Lawyers are very expensive. That is a fact of life. And AI, famously, is not. But you cannot have a bigger but on a PowerPoint slide. I tried. But I've also used a lot of AI for legal stuff, for like background research and things like that. I also happen to know that it is oftentimes very wrong. It is very dangerous. It creates very big and potentially very, very, very costly and even company destroying mistakes. So, your 3 rules for this rule is that AI is better than nothing. When it comes to you guys have a company, see, and when you start a company, you start adopting tools, you start using assets. You have a lot of these like tiny little contracts that you have to accept when you start using a licensed tool. When you start, you take like a you use a tool in Unreal that's like a third-party tool, and it has its terms of service that you accept. Most of you probably would just accept it without reading the rules because it's too much work, and most likely it's okay. Throw that thing into whatever AI tool you use and use that as your terrible lawyer for the time being, instead of using nothing, instead of not going through that terms of service contract. Use an AI tool. But that's AI is better than nothing. But AI plus a real person, so someone who has gone through the hurdles that you are now going through, or just a person who has experience of these things, is much better than using AI, because AI makes big mistakes, and most likely a person who has gone through the same hurdle has some experience, enough experience that he will spot the biggest, most dangerous mistakes. So AI plus real person is much more okay than just AI. And then a shameless plug when I say that a lawyer is much better than AI, and a lawyer is also much better than just a random dude who has gone through a hurdle. A lawyer has gone through hundreds of those hurdles. So really what this boils down to, that points 1, 2, and 3, is with the absolute least critical stuff, AI is fine. And the more critical that whatever you're agreeing to becomes, the more you need an actual lawyer or an actual person who will ensure that nothing gets destroyed. Something the chat rather have to say or nothing, glad to get. Yeah, exactly. ChatGPT is, and other tools, they're most of the time they're really good, but they just make really big and dangerous mistakes, and they are bad at nuance, which is exactly what a lawyer is good at. So yes. Now you have my permission to go to sleep. The 2 biggest lessons are out of the way. Then let's move on to founding your limited liability company. But before we go into the paperwork of it, a little bit about how does a limited liability company actually operate in a nutshell, like the very, very core basics. Legal, very, very legalese term. A limited liability company is a legal entity. What the hell does that even mean? Well, basically, it means that the limited liability company in itself can make its own agreements. It can accept things as the company itself. The founders do need to sign those. Basically, the company can itself have responsibilities. A limited liability company consists of shares. This is, I think, the Finnish term for LTD, osakeyhtiö, so a share company. Really drive this forward, because a company is basically the collection of its shares. So if a company has 1,000 shares, then that company is basically just consists of tiny little pieces that make up the whole company. That liability then mean? Well, it just means that if you start a company and you've got 4 founders, you all, let's say, during the span of whatever years have put in, or your shares are worth 100,000 euros, let's say. And then something terrible happens, your game sets everybody's PCs on fire, and you have to pay 200,000 euros in damages. Well then, you are only liable for that 100,000 euros that you've got in the company, and not for the rest 100k that would go from your own personal bank account. No, you're only liable for the amount that you put in the company, and you own the company. So you will not go personally bankrupt, even if your company would. It makes just operating a lot safer, because you know that you will still most likely be able to eat and not go on the street if something really bad happens. A company basically has 3 tiers of bodies that make decisions. You've got the shareholders. So let's say there was I'm going to take you guys as an example. It's way up there. Well, there was someone that said that you are a team of 4 devs, and you 4 devs now are going to found a company. You're all going to agree that you have 250 shares each, so 1,000 shares. You are now the shareholders, and those shareholders make decisions that are like the biggest decisions of the entire company. You're like the boss of everything, the shareholders. Under the shareholders is the board, and the board is elected by those shareholders or decided by those shareholders. And the board then runs the day-to-day operations of the company, and they make decisions themselves, and they just kind of run things. But still, the boss of the board are the shareholders. And then under them, not always, but quite often, is the CEO, Chief Executive Officer, toimitusjohtaja in Finnish, who is elected by the board. And they also have some, like, depending on the company and the task, but they have some tasks here and there. The CEO is in the mandatory position, but you can have it. But that's generally how most companies are operate. Their bigger ones have extra tiers, but you don't need those. A company has 1 to 5 board members, and since you guys, when you're about to found your company, most likely if you're under 5 or 5, you're probably all gonna be board members. That makes things a lot easier. If you are 2 or less, you also need to have a deputy board member, so someone that, if you're sick or get hit by a bus, can step in. And if you're 3 or more, you need to have the chairman of the board. And then where these decisions are actually made, so the shareholders make decisions every single year, at least once, in a annual general meeting, where you basically just, you've heard the typical meetings when you see that, oh, we are at quorum, and then you start making decisions, and then you vote on different things. And then the board meetings are a little bit more relaxed. There's much less that the board has to, by law, actually decide on. And the board makes decisions in board meetings, and they just have them whenever they feel like they should have them. So no official 3 meetings a year. Then to the paperwork that one needs when you are founding a company. There are 2 main papers that you're going to need. Plus the Patent and Registration Office requires some files to be for the forms to be filled and stuff like that. But the 2 big ones are the first one being the Memorandum of Association, so a perustamissopimus in Finnish, This document is very simple. Mine is probably about half an A4 long. It's all public. You can find them online. I think you can get them for free, but they are public information. Consists of like share info. So again, if you guys have 4 people, everybody has 250 shares. It has the names of all the shareholders and how many shares they have. Has the like who is the board of the company, what's the board consist of, like how many board members are the shareholders going to elect. Information on the financial auditor. Your memorandum of association would probably say empty at this point. It doesn't need to be filled. It's going to say if you're going to have a CEO, again, if you want one, you don't need one. It's going to tell your financial period. Probably, if you can, should have it from the start of the year to the end of the year. For the like to actually get this document, they are definitely line you can use, but the Patent and Registration Office has a really good fast track for starting companies. They give you a template. We're not even a template. They're just going to fill it for you. You're going to check a few boxes, and they're going to make the contract for you. So basically, you can use the Patent and Registration Office's fast track to get this contract instead of actually making it yourself, which really does help. It speeds things up quite a bit. It's also a faster process to start your company. They process those applications really quickly. Over the ones if you make a custom one. So I really heavily suggest using that one, with a few caveats I'll go to later. Second document you're going to need is the Articles of Association, which is yhteisjärjestys in Finnish. You need a little bit more fiddling with this one over the Memorandum of Association. Well, this has your company name, your domicile city. So say you're in Kajaani, it's going to have Kajaani. Your area or field of operation. So for example, software development, whatever your company does. And then with this terrible highlights, I've marked these things that need a bit more fiddling. Who can represent the company? So you need to decide who in your company can make decisions on behalf of the company. So for instance, if you guys want to have a chinchilla farm in Peru, who can sign that contract to have that chinchilla farm in Peru? You can decide it to be just the chairman of the board. It can be any board member. It can be a combination of the above and the CEO, or it can be 2 board members like together. But that's up for you to decide. It really depends on how you guys want to run things. If you want to keep it light, if you don't want to keep it on one person, then you probably can have everybody to have the rights to represent. But remember that then everybody will be able to start those chinchilla farms in Peru. Well, not actually. There's things to prevent that are that out of the pocket, but I think you get the point. Who can make contracts on behalf, like big investments, like a software acquisition that costs you 10,000 euros a year, something of that nature. A lot of people are talking. Interesting. Then a thing that you will have in the Articles of Association is a thing called the redemption clause. This is very important. You're also going to have, I'm going to repeat this in the shareholders agreement part, but essentially what a redemption clause is that if for some reason the shares of the company that you shareholders have, your 4 founders have, are transferred outside of your company. So for instance, as I said previously, if you don't make a prenup, believe that love is eternal and you're never going to break up, and then you break up, and then you don't have money, so you might have to give some of your shares to your ex-spouse, and most likely the other shareholders do not want this, because then you would have basically a random person in your company as a shareholder that they could make decisions like other shareholders, and in addition, that person can, well, if they're the ex-spouse of the other person, then it might be that they're not too friendly with this ex-founder of it, that is founder of yours. So the redemption clause basically says that However, decide the company or the other shareholders can first redeem the shares that would be transferred to someone else. So instead of them being transferred, the other shareholders can buy those shares before they transfer to someone else. So in addition to keep the shares to who the shareholders actually want the shares to be kept with, you really need the redemption clause in your articles of association. With the Patent and Registration Office's fast track, you can, this is just basically a box you tick and then a few parameters that you check and you change according to how you wish it to be. So really important to have this. How about specifying what type of contract persons A and B are allowed to sign? Well, yes, you can do this. There's also another thing that you can add to the signing rights, which is that you can have basically the board can authorize, let's say the board can authorize other people other than the ones that are marked in the I'm gonna go back here, in the memorandum of association to actually be article of association to be able to represent the company, and then you can create a document that says that this person can represent the company in matters A, B, C, and D. So Andreas handles HR. Would be great. Well, yes, you can make let's say you don't want them to have general signing rights at all. So Andreas could, let's say you only have the chairman of the board to have the rights to be able to make such a contract, and then what you could do is then in this article of association say that the board can give a right to other people to also sign, and then you could make this contract that Andreas, hey, you can manage and sign things related to HR, employment contracts, and things of the sort. So that is what you can do. In here, I think it's a bit excessive to go into detail in the articles of association, give specific people specific signing rights. It's good to hear just say general signing rights, general representation rights, and then if you need to go more into detail, make a whole separate agreement with that person for those specific matters. Yes, then after the redemption clause, a second thing that's really, really important that is not a part of the default fast track for Patent and Registration Office is a thing called the consent clause. So the consent clause is kind of similar to the redemption clause, but in this one, you need to ask the consent of the company before you can even in any way transfer the shares. So it's a bit more, it's a bit more prohibitive. That's the word. And basically, this is for situations where the company or the other shareholders wouldn't have money, for instance, to redeem the shares. Then some person from the outside would be able to get them. But this one is not in the fast track, in the templates, but it can and should be covered in your shareholders agreement. So don't let this steer you away from using the fast track, because I think it's still very, very, very helpful, because you can tackle this thing very well in the shareholders agreement. Well done. Quick rundown of the decisions that you need to do before founding. So to set up the board, who's going to be what the board will consist of, I suggest just having all founders there. How many shares will you have? Just have any easily splittable number. It can be 10, it can be 1 million. But usually I think a good thing is go with about 1,000. So if you're 4 people, you can just do 250 each. If you're 5 people, you can do 1,500 shares, 300 shares each. Something like that. It's just an easily splittable number, and just from the top of your head, there's nothing that says that it cannot be number XYZ. You just come up with it. But 1,000 is usually pretty good. And then you're going to have to decide if all shares give equal rights. So for instance, some shares can give 2 votes, some shares can give 1 vote. So when voting happens in a company, in an annual general meeting voting happens, basically 1 share that you have is 1 vote. So you're not going to vote once, you're going to basically vote 250 times if you have 250 shares. So If you have some shares that have more votes per one share, then, well, the votes are going to be different. But for all intents and purposes right now, just have one single share with one single vote. Don't do any trickery. You're just form a normal standard company. Don't do anything crazy. Do you want someone to be the CEO? I recommend it if you have someone who wants to deal a little bit more with the admin side of things. It makes some things easy, like dealing with some officials or like banks and stuff like that. Because if you're a CEO, then usually people do not ask any further questions if you're able to represent the company. So I think it's really good to have one, but it is not necessary. It's not mandatory. It just makes day-to-day operations often a bit easier. And then you need to decide who makes the decisions for the company, or who are allowed to do that. And that's up to you to decide. Just talk with each other. Then just last general tips and tricks. Sadly, yes, that is true. And there's funding applications also make it easier to handle. Yes. Sorry for anybody who happens to not be Finnish speaking. Patent and Registration Office is basically Finnish and Swedish only, which sucks. But this means that the Articles of Association and the Memorandum of Association will be Finnish only. You can, or Finnish or Swedish only. What you can have is an unofficial English translation, but that cannot be the official version, which, again, I'm going to say once more, sucks, and Patent and Registration Office should step up their game, but it is what it is. Here's the caveat for the fast track of Patent and Registration Office for the templates. You can only do it if all of your shareholders have a Finnish social security number. If even one of you has any other social security numbers, you're from somewhere else, you don't yet have a Finnish nationality, then you will need to do a custom template method. You can probably find the templates from PRH online, but still you cannot do the fast track. Also, sadly, if you have someone without a Finnish SSN, it also will make things slower because they will need to do things manually, and there's a little bit more trickery involved that the PRH needs to do. You're going to be asked if you want to start a company with share capital. Somewhere around online, there's still floating information that you should have some. Do not. It's going to make things a lot harder. Remember that limited liability banking is terrible. It's expensive and it takes a lot of money. It takes a lot of time. I opened my bank account in about 2 months since my initial message to the bank. So yeah, everything in LTDs takes a lot of time. So be prepared for that. It depends on what providers you use, but generally it can take months, and be prepared for that. If you're fast and lucky, that's good. Breather. Quite a way to go. The rest, this was the longest section of all. No worries. It's very important. Shareholders agreement. Should you have it from the get-go? You can. You don't have to. It is not legally mandatory. You probably should make it with the other documents at the same time because they have things in common. So making them in bulk is really, really useful. But if you need to set up your business ASAP for some reason, if you've got a deadline that you need the company for, then you can form a company without a shareholders agreement. I really wouldn't, but you can. It's possible. What is it even? It is by far your most important agreement, without any question. It details all rights and responsibilities of the founders. So for you, the shareholders, it is a very long and intimidating document. It can be up to 30 pages. It's intimidating. Just brace yourself for that. It has a lot of text, a lot of legalese. It is a bit of a difficult one. The shareholders agreement, as I said, it's 30 pages, or can be 30 pages, so it includes a lot of things. But for example, it has things about how to value your shares. So for the redemption clause, how much should one share cost? It has the mechanics how to calculate that. It has those transfer clauses I talked about, the redemption clause, how shares sold, bought, that kind of stuff. It has a work commitment of some sort, because you probably want the founders to all have some sort of like, yeah, we are not just going to be here and kind of like freeload and chill. You're actually going to be doing something, so have some sort of commitment for them all to actually then work. Then there's usually stuff about IPR transfers. I'm going to go into more detail about this, but it's just going to be in here. Your typical NDAs, don't go blabbering about company secrets to others. And then usually it includes a very scary-looking contractual breach penalty. So, for instance, if you breach this contract, you will have to pay a fine of 30,000 euros, which is the small side of things, because it's not a legally mandatory document, and breaking this agreement is not a violation of the law. You need to have some other method of ensuring that people comply. So it's going to be scary, but it's very necessary and it's normal. Where to actually find this document? Unless you have a pre-existing kick-ass template or an on-call lawyer, there's a thing called Startup Foundation, and they have a thing called Series Seed Shareholders Agreement. You can find it from seriesseed.fi, and there's multiple versions, and just pick the one that is without investors. It is a really, really kick-ass. I think it's from like 2019, something along those lines. So pretty newish, made by I can't remember which attorney company, but still which law firm. But it is industry standard. A lot of people use it. A lot of startups use it, and it is really good. So when you actually get that one, or basically any other shareholders agreement, what should you do with it? First, read the whole document. It is commented, so every single most of all segments have a comment or two about what the things in there actually mean in like plain English. There's your legalese one, then there's like basically this means this. Just read the whole agreement and read all of those comments. It's gonna take a long time. You're gonna be really sleepy. Do it in a few bits. Then comment on those things. All of you founders, all of you do this, and then comment on those things, what you don't understand, if you already have some ideas what could go here in this blank parts, and then talk those things through, those things that you marked yourself, and just go through your own comments. Then, as I said, you're going to have in your articles of association, you're going to have a redemption clause. You're also going to have one here in the shareholders agreement. Make them match so that they're the same. You don't want a clash between the two, because then by following one, you can break the other, and it's just very confusing. The consent clause I talked about before with the articles of association. You're going to have it here. There's a template already in the Series C document, so no need to worry about that. Just tweak it if you need to. And again, as with the previous one, ChatGPT is a good help, but someone who has gone through this mill before is way better. So if you have a friend or family relative who has gone through signing an SHA, go to them first. And then, of course, always the best thing is to go to a lawyer. And if there's one agreement that you should run through a lawyer, it is this one. This is by far your most important agreement for you founders. This is absolutely essential. Okay, well then you've done your SHA, and then you get someone to work on your project that is not one of the founders. So a contributor, a sound guy, let's say, someone makes music for your game. Well, I'm gonna, before I go into like freelancer stuff, about employees. Really think long hard if you're any employees, because they require a lot more overhead, they require a lot more planning, and they are a lot more expensive than freelancers. So unless you are really, really, really sure that you want to hire someone, use freelancers. All right. So when and how should you make a contributor agreement? The when is always and before anything is done. And how? For shareholders, this agreement is basically a shareholders agreement, so you already have this done. For employees, it's an employment contract. If you go that route, be careful. And for freelancers, it is a freelancer agreement / project agreement / it goes by different names, but project agreement, order agreement, purchase agreement, freelancer, whatever. All basically the same thing. And what are those contracts going to say? They're going to have the scope and schedule of the work. So when the work will be done, how big is the project? So it should be a bit specific. It can be just make all the sounds in the world. It's like make three songs for our games for the water level, something of the sort. Compensation, of course. Hopefully you're able to pay these people, and probably it's good to agree beforehand how much that should be. Then the responsibilities of freelancer really important. What are they expected to do? How are they expected to do things? Which tools should they use? They should ensure that they don't break anybody's copyrights. They should work diligently and use industry standard practices and stuff of that sort. My phone just showed that my internet dies. Can you guys still hear me? Hopefully you can hear me still. Yes, I think I'm still live. Wonderful. Liability for damages. What happens if the freelancer does something nasty? And for instance, you get a coder, and everybody who plays the game, their computers explode because their C++ was not quite right. Immaterial rights transfers. So all of the work that they do should be transferred to the company. I'm going to go, again, more on this later. Non-disclosure, like in the SHA. So do not blabber about company secrets you hear about when you are doing that freelancer work. And what happens if someone breaks the agreement, of if there are disputes. So which court do you go to? Are there fines? Are you liable for something? Are you not liable for something? Standard stuff. You're going to have every single template. Where do you get one of these agreements? There are plenty of examples online. Just keep it simple. Ensure that there's no employment if it's a freelancer agreement. It's very easy to make a freelancer agreement that then turns into an employment agreement. So just Google how to not make that happen. There's plenty of examples. And there's a thing called IT 2022 General Terms and Conditions, which you can reference for good practice, like industry standard clauses. What about internship agreements if you don't have money to pay? Internships are a bit different. There are all, well, it depends. If it's a zero non-paid internship, then it needs to be part of a school's curriculum, or it needs to be through the offices. That's the only two ways you can actually have one without paying any compensation, and then you don't need to worry about as much stuff. Then usually the school or the offices will handle those matters. But just ensure that there's that behind it. I think most schools, game design, because we have a mandatory one, so we would here at Kajaani at least would qualify for those internships. IPR, really important stuff. Immaterial property, intellectual property rights is what this is short of. There are different IPR forms, a lot of them. You're mostly going to need these two, and maybe a little bit of this one. So copyrights, licenses, and trademarks. So what is copyrights? You've heard this term millions of times. It is basically just the creator's right to decide what is done with their work. So as you can expect, if a game is, as I write here, a compilation of thousands of copyrighted pieces, if every one of those pieces is owned by different people, and the rights to decide what is done with them is all different for different people, there would never be a game that would be commercially released. So you should always assign the copyrights to the company that is creating the game. Then they're all under one umbrella, and then there's no like conflicts of like 10 different people having 10 different ideas of what to do with their creations. And this really you need to do this. This avoids biggest and most damaging arguments. copyrights are not registered. They happen automatically. If I made a thing on the board right here now, it would be copyrighted if it was original enough, and it's there. It's copyrighted. I don't need to register anything. Yeah, this is also the end result of the work is copyrighted, but not like ideas or theories. So if you're just like bouncing around, hey, what about a game about a hedgehog on a balloon? Yeah, that idea is not copyrighted. The actual end result and execution is the thing that matters. Always transfer these in either employment contracts, freelancer contracts, and shareholder agreements. Always, always, always. And that's why the number one reason why you always need a contract from the get-go, because you need to start transferring instantly. Licenses, you've probably heard of these. Basically, the license grantor can give other people the right to use and utilize their licensed work or their copyrighted work in some certain way with some restrictions. So you might encounter licenses in things like game assets, you get like 3D assets that are licensed somehow. Or you used a tool like Unreal Engine has a license that says that, hey, use this tool, but if you make over $1 million, pay 5%. Read these very, very carefully. I'm going to repeat it again. Read these licenses. You can really shoot yourself in the leg if you don't. What you can do is something called poisoning the well. You might release an entire game, and you might have one singular 3D asset that is under the wrong license, and that might lead it to be so that none of the game can be commercially used. So you will not be able to make a single penny out of the entire game. Always make sure that the license that you're using is suitable for your purposes. Every single time, for all tools, for all assets, for everything. That's number one priority when using everything. The terms of service and user license agreement and just license clauses that they might have, always read them. And again, ChatGPT is a really good tool for this. If you can't do it yourself, but you should, but just remember that. Trademarks, I'm not going to go too much into these. Just only worry about this if your game really blows up. You can protect your game name and your studio name and logo. It costs not too much money, but it's a bit of a paperwork thing. You probably should pay someone to do it for you. It's not worth yourself. A lot of paperwork for the thing that's actually pretty cheap. There's services for that, and there's like EU grants you can get for that. So only get if your game blows up, call someone who knows how to get it for cheap. I can point you the way if that happens. Quick note on patents. A lot in the news lately. You've heard the Pokemon Go things, patenting, throwing balls on monsters and spawning things. You will not need them. With 99.99.9% certainty, you will not need patents. They are mega expensive and they are giga time consuming. You will not need them. Unless you're making something physical and very, very, very weird new, and then even probably not. So don't even think about that. Data protection. What is data protection? You've heard the GDPR probably, you've seen the cookie banners, you've seen I accept privacy policy, but data protection, there to protect personal data. Personal data is all data that is related to an identified or identifiable person. The actual definition of it, a bit clanky. But basically, if you have any data that can be linked to an actual person, that can be an IP address, that can be a name, that can be an address, that's personal data, and you need to protect it in accordance with the GDPR. So it can be employees' data, freelancers' data, and then your customers' data, or potential customers' data. For your games, probably things like non-anonymized player action data. So like, where do players die, and then that associated with their Steam handle, player genders, things like that nature. Email lists, if you've got email lists, you've got people's emails, that's personal data. And then if you collect any of this stuff, you need to have a privacy policy. And if you need a privacy policy, just steal it. Don't actually steal it, but there's so many so many privacy policies online. You've browsed through thousands of them. Just see the most relevant to you. Take the things that you think are relevant to you, and then just change the wordings. Change it. Don't. That's also copyrighted work. The terms of service are copyrighted work, so don't just copy it, but just you see what they have, and then just rewrite it in your own words. Then the thing that we've all accepted 1,000 times but never read, except sadly me. I've done that quite a few times. It is not pleasant, especially writing them. If reading them is terrible, imagine writing them. Terms of service. What, when, and why? What are they even? Basically, rules of the game. And what happens if players break those rules? They can limit your own liability for stuff. If your game causes some problems, for instance, people's computers set on fire, or in Pokemon Go, there was a thing that players got run over by cars when they looked at their phones. So things like that, you can say, hey, we're not responsible if you do goofy stuff or use this as it's not intended. When should you at least have a terms of service document in your game or for your game? If you have any online functionalities, absolutely have it. If you have any transactions other than, buy the game on Steam, any microtransactions, any coins, anything you have in your game, always have a terms of service. And if you have any features that might cause some harm to the player, very vaguely speaking, harm to the player, like Pokemon Go. And why should you have it? Just to protect your own butt and kick nasty players. You can point to your terms of service and say, hey, you broke this, and now you cannot play the game anymore. You're not allowed to join the service. End user license agreement. What, when, and why? It is very similar to terms of service, but it's that usually, often these two are kind of also interlinked. It might be that the end user license agreement actually has the terms of service, but it also has the license aspect of it. So it describes what license is given to the player, or what licenses, or the licenses that the things that the player makes, the player has to give you. So in Roblox, for instance, you can create things. So Roblox, of course, wants a license to use. Roblox wants you to, if you use their tools, Roblox wants you to use your creations in their marketing materials and things like that. And when should you have them? If you want to give players a license to use your game's assets in a particular way. Or if you have any user-generated content, always have it. And then remember that some engines and tools, and this is funny because Nicholas just mentioned the same thing, that yes, some tools, distribution platforms, engines, stuff like that also require you to have an end user license agreement or a terms of service. So I'd say it's a good thing to have. And why should you have it? You should have it to protect your own butt, to be able to use players' creations if you need to, for your marketing materials and stuff like that, and ensure that the players comply with your license terms. So don't use your licensed materials, your tools to create NSFW Mario art. I don't know, just to show them that, hey, this is the appropriate use of our license. Don't go outside of it, or you can be kicked out of the game or something like that. What should be in each document? Well, as I said, rules. What happens if you don't follow those rules? The usual, we are not responsible for anything. That might not always fly, but you should usually have that. If you have an end-user license agreement, you want the license terms. So basically, usually it's like, hey, we can use your stuff for free. Like those Minecraft creations, Roblox creations, we can use those in our marketing materials, and we can just display them on our game in our lobbies and things. You can see pictures of them, and that's complete. That should be okay. And then the other side of it, so how can you use our license material? And then again, if you need, where could you find one of these documents? Again, you just use the word steal, but again, go find something that's close to your game. See how they laid out that thing, see a few examples, and then just write the same things in your own word. you have tools nowadays that can help you. But just there are so many examples. So the lack of not having one of these documents is not an excuse to not have them, because they're so easy to find, because there's thousands that you can access just from your Steam library. You can see probably all of us at least 50 examples of terms of service and end user license agreements. And then just to wrap things up a little bit, just a random assortment of other miscellaneous tips and stuff. There's a thing called the entrepreneur's pension insurance that you need to have if you are an entrepreneur. There are ways around this. Not all entrepreneurs need to have this. If your work contribution or the amount you're paid is under a certain threshold, 1,900 euros is a lot of money for, let's say, a game project that might not in the beginning be making a lot of money, or at all, since you're just developing it, for instance. So do your research, see if you need to pay this, see if you can qualify to the group of people who don't need to pay this, but just do your research and be mindful of this. You might be eligible for a starttiraha, so a startup grant. It is 740 euros a month, I believe. And you can just contact the TE office about this when you, or should do your research beforehand, probably. But this is a very valid thing for many. You might need to do some trickery if you're a student, but being a student is not a prohibition of getting this money. But you can just not be a full-time student, I believe. But just do your research. If you're not getting paid from someone else a substantial amount, well, yeah, you can ask Andreas for tips if he's going to do that. But yeah, just do your digging. It's a substantial amount of money. It's, I think, more than the student benefits that you get. So do your research. I highly, highly, highly recommend for all of you companies, especially if you start moving any money around, to invest in a bookkeeper. They help you with a lot of your bureaucracy. You want to focus on creating your game. You don't want to focus on paying taxes. I mean, you still have to do that, but on the house. You don't have to worry about your annual financial statements that you need to do, your double bookkeeping, which actually, if you have a lot of purchases and stuff like that, it can take a bit of time. But just, I really, really highly recommend it. It's not that expensive. I personally use a company called Mertauja. They are focused on small businesses. They are very affordable. I can't remember exactly how much I pay in the year, but probably like 200 without the end annual financial statements, but like still pretty cheap. And I've got this lovely 70-year-old, almost 70-year-old Rita, who is a rock solid professional. She's awesome and a sweetheart, and she's helped me out so much. I highly, highly, highly recommend investing in one, especially when you start moving your money around. But that was the me part.